Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions, and I have a good topic for you today. And this topic, so the topic here is um, you qualify for the green card, but, and there's a big but, right? But in this case, I'm going to talk about a very important USCIS update. They issued a policy guidance, and this is exciting news because if you have entered the United States without permission, you know that you may not qualify for adjustment of status, even if you do have a US citizen spouse or child. How under, of course, there are certain exceptions like VAWA, but then there is another way to get around this under this circumstance. So say you came here to the United States, you may have come without permission, or you may have been here and then you may have gone through deportation proceedings for unlawful presence. And you got deported, you had an order of deportation, you did not leave the country. You didn't leave, or you left the country and then came back in. In this case, the USCIS has issued new guidance that states that if the time has passed since your deportation, so that could be, it's usually 3 years if you overstayed or you were here unlawfully for over 180 days, that's a 3-year bar. If you got deported on that basis and now you have a 3-year bar, or if you were here for a year or more and now you have a 10-year bar, if 10 years have now passed, whether you stayed in the United States or out of the United States, you're no longer inadmissible. Now, it's a given when you're already outside of the United States because, when you're outside of the United States, 10 years has passed, then, and of course, as long as you don't have other basis for inadmissibilities, you would not be found inadmissible. However, if you are here in the United States, you had an order of deportation for unlawful presence, and maybe there were other issues involved. But if you had, the main thing was you were deported on the basis of unlawful presence, and now the 10 years that you were supposed to stay out of the United States has passed, you never left. You could possibly apply through adjustment of status despite not having left, and be able to get the green card while you're here in the US, as long as the 10 years or the 3 years has passed. So the policy guidance that they have released is that after the deportation order, they don't care where you were. They don't care if you stayed here. They don't care if you are outside of the US and then you returned. They just want to know that that time period has passed and now you're reapplying after that time period. Now, it's not to say that you won't need a waiver because, for example, if you have, an additional ground of inadmissibility. When I say ground of inadmissibility, by the way, I mean that you may have past immigration violations or criminal issues that have caused you to be inadmissible, maybe on a longer basis than the 10 years. But if you're already here and you qualify for the green card and that period of time that you were supposed to stay, that period of time after the deportation has passed, then you may just need a waiver now, but you can still stay here and apply. So this definitely is on the complex side of immigration, but here's what I want you to walk away with, right? If you've had an order of deportation, or if you were found to be here unlawfully, and you were here with unlawful presence, that time period has passed, right? The 10 years that you were supposed to stay out of the US, but say you are still here, you never left, or you left and you came back, even if you came back without permission. If that time period has passed since you had the removal order, the deportation order, and say you qualify through a family member, you qualify through a spouse, maybe you may even qualify in other ways, then you could apply for adjustment of status. I do have to confirm this, right? So don't walk away saying, yay, yay, I get to apply for adjustment of status. I'm giving you information for you to understand that you may have options. But this is where it's important for you to schedule a consultation for me to delve into your particular facts and make sure that that's going to be the case for you. But this is a very, very important policy clarification that they've made. And this is based on the USCIS decided to issue this guidance because the court there, this is based on court orders. And so now they have said that no matter where you are, whether you stayed here in the US, you left and you came back, they don't care where you spent those 10 years. As long as you didn't apply for anything in the 10 years, and now the 10 years have passed, you could qualify for adjustment of status. Now, let me tell you who this fixes the situation for. This may fix the situation for individuals who've had past deportation orders, and you've basically been living here in the shadows because you felt like you couldn't do anything with a deportation order. Now, if a significant amount of time has passed over 10 years, you need to see if you could apply through your relative, through a spouse. For example, if you're the spouse of a US citizen, you had a past deportation order, and that is why you have not yet applied for adjustment of status because you're thinking that you will not be approved. Then in this case, if more than 10 years has passed, then there is a chance that you could qualify for this. So this is where it's important to evaluate your situation, get in touch, and we can talk about your particular facts, confirm you qualify, and get started. Now, say you've had a past deportation order, time has passed since you've been out of the US, or as I said before, you could be here. You could be here, or you left and came back before those 10 years passed, but now the 10 years have passed, you're not inadmissible. You will not be considered inadmissible on that basis. But say you have other issues going on too that make you nervous. So say you've had past criminal issues, or maybe you've had misrepresentation, maybe you used a fake passport, maybe use somebody else's name. And in a case like that, could you still qualify? And the answer is you may. I'm going to use a good example here. And it's, for example, if you're the spouse of a US citizen and you had a past deportation order, but it has since that time period you were supposed to, that they said you were barred, has passed, then adjustment of status is now back on the table for you. And then if you have additional issues, we could look at a waiver to get forgiveness for those additional issues. But in order to be successful at this, you need to get the right help. And this is what I help my clients with. Right now is a good time to apply because this is a great policy that opens up the door for so many people that thought they could not apply. So you can give us a call. You can go to the link in the profile, schedule your own appointment, or you can give us a call and the scheduling coordinator will be more than happy to assist you. But this is an important piece of policy guidance that really creates an opportunity for so many people who qualify through family members. But there was that one thing where they were here, maybe they came in without permission, maybe they had a past deportation order, and they don't know how to fix that situation. Well, I'm telling you, this could be that fix right here, but you need to make that move and get the advice you need. Go ahead, do it now so we can get started. Now is the time to apply because there's so many opportunities now. They're opening up the doors in different ways through different policy changes. And keep in mind that we're in a very volatile situation where, unfortunately, based on the political climate, all of this could change and they could shut the door again on immigrants. And this leads me to another important update that opens up the door for so many individuals who may have felt stuck before. And this is for individuals who are or were, you were on TPS and you had advanced parole. That's a travel document. If you traveled on the travel document and came back in on, then guess what? If you entered without permission previously, way in the past or sometime in the past, you entered the country without permission, then you got TPS because your country was designated a temporary protected status country. Then you left. You got TPS, you got a travel document, you traveled, and then you came back in successfully on that travel document. Guess what? You now can show legal entry into the country to be able to qualify for adjustment of status through a family member and even through employment. So it's a very, very important change, very, very important benefit. Now, during the Trump administration, that existed before the Trump administration, during the Obama administration, where traveling on advanced parole, so DACA recipients could do it too, where when you traveled on advanced parole and you came back into the country, you would now have legal entry. So they wouldn't look at your illegal entry, they would now look at your legal entry with advanced parole. That is now back in the books. So now we have that. During the Donald Trump administration, they took that away. They said that will not count towards legal entry, and now it's back. So these are opportunities that you need to take advantage of now, because we don't know when that's going to change, right? We would hope that we can exercise our rights to vote, exercise our own judgment as people. If you're a US citizen and you have relatives, or you are an immigrant but you have relatives who are US citizens who can vote, encourage them to vote for individuals that are going to encourage humane solutions for the immigration process. Like these are solutions that enable people to stay unified with their families and stay in the United States after years of being here. So those are very, very two important policy updates I needed to tell you about. Go ahead, schedule that consultation, and let's get started. Now I'm going to go to your questions. Thanks so much for listening. Now I'm going to go to questions. Go ahead, put your questions in the comments on YouTube. Go ahead, put your questions in the comments on TikTok. I already see those questions. Thanks so much for sharing. Thank you so much for the love. I appreciate it. So now let us get started with questions. Why is the wait so long for the Canadian visa? Oh, I'm so sorry, but I am not a Canadian immigration attorney. We know what it's like here, because it's very long on the American side too, but you have to consult with a Canadian immigration attorney. Carlene, good afternoon. Safrana, nice to see you. Hi, your F3 category is approximately 12 years. Unfortunately, yes, it's approximately 12 years. Thanks for the follow, Tiffany, I appreciate it. October will be 12 years for us, but when I check online, estimated time is showing we have approximately 4 years more. Not sure if there's a special website. So there is a website that you have to check called the National Visa Bulletin. You have to check there and look at the priority date on the I-130 petition. If you don't have it, your relative who is sponsoring you, so that's going to be your US citizen parent, it's going to have the copy of the I-130 receipt, and it's going to have the priority date on there. You can compare the date. If your date comes before the date on that website for the F3 category, then it means that you are going to be processed. You're currently being processed. So it's called the National Visa Bulletin. Just look it up and go to the official website on the Department of State. Hey, you visa still taking 5 years just for bona fide certification? Why taking so long just for bona fide? No, it's not. While it is, we are still very impatient. It's going to be substantially reduced because now they have said that as soon as they're not taking 5 years, as soon as you properly file your application, they're going to issue a bona fide determination letter. And if you submit your I-751 or submitted it, if you've already submitted it, then you could get your work permit. So you don't have to wait the 5 years to get that bona fide certification or to get on the deferred action list. They are going to start reviewing if your application is properly filed. You've done your biometrics, so properly filed, done your biometrics, you submitted the U certification, then they will consider it bona fide and then issue the work permit. Of course, even though that's supposed to shorten the time, we're still very impatient. We're looking, so I've seen as short as 4 months, but of course, this policy just happened last year, and some of my clients are still waiting, but it's supposed to shorten it. If a person ain't get back their green card sent to renew, could they still get married? So you're not really supposed to send your, no, I don't know which green card. You're not supposed to send your actual green card unless you're sending it in for correction, and even then, you're not supposed to send in your actual green card. So I am not sure why you would do that, but there are ways to still show that you are a permanent resident. You can set an appointment to get what's called an I-551 stamp. The I-551 stamp is going to be a temporary evidence that you are a permanent resident. You have to schedule an appointment with the USCIS. So call them, let them know that you need evidence that you're a permanent resident. You can use the stamp to travel. You can use the stamp for work purposes. You can use the stamp just like you would with a green card, except it's placed in your passport. So set that appointment and get that I-551 stamp. And then in that case, you could get married. I don't know if you want to get married to sponsor your spouse, but you could use that as evidence of your permanent residence in the meantime. And and hopefully you retained a copy of the front and back of your permanent resident card, because when you're applying for marriage base, you wouldn't send your original green card anyway. My dad's green card expired in March, and how far are they making the appointments? So if his green card expired, I don't know if he had a 10-year already, but it takes about a month and a half to schedule the appointment. It really is a pain. So and when I say appointment, I'm thinking you mean the appointment to get the stamp in the passport. He should call the USCIS. He needs to apply for a renewal, then call them and ask them for evidence of the. Now, keep in mind, if he's applying for a renewal, he'll also get an extension letter. The extension letter also serves, it's usually the extension letter is about a year. It proves that you're a green card holder. You'd walk around with it with your expired green card. If that expires, then you'd need to make an appointment to get what's called an I-551 stamp. All right, keep those questions coming. For citizenship exam, do I take it on computer or what? So no, it's going to be, you're going to be sitting in front of the officer at their desk, and you're going to, the officer is going to ask you the questions. It's not multiple choice, and you're going to have to answer, answer the questions. So it's not going to be on the, when it comes to the civics, when it comes to the reading and the writing, they're going to have a little screen, and the screen is going to, they're going to ask you to write the sentence on the screen, and they're going to ask you to read the sentence on the screen. All right, let's keep going. All right. How long does a USCIS take to send receipts for the VAWA? So right now I'm seeing anywhere from 2 weeks to 8 weeks. If a 70-year-old marries a 20-year-old to give her citizenship in the USA, is that a red flag? That can be a red flag. However, there's no limit on love. There's no limit on there's no age limit. However, if he's just marrying her to get her the green card, that's a problem. That's not legal, and it's called marriage fraud. How long does USCIS, so my husband's status updated, interview is scheduled and mail, any idea when his interview will be? You'll have to wait on that interview notice. Thanks for the follow, thanks for the shares, I appreciate it. So you're currently waiting for an I-130 to be approved. So you're currently waiting for an I-130 to be approved. Is there any way I can get a visiting visa? So there's nothing that says you can't try, but it's going to be hard to do that. 2011 is priority date. 2015 petition was approved per NVC letter, but until to this date, haven't received any notice from NVC for documents. Submission or payments. So unfortunately, you just have to get in touch with the NVC to see what's going on there. My daughter is with me in Jamaica and I want to give up the green card. So you'd have to do a consultation because that's a very personal decision. And, there is a formal way to give up permanent residence. So, that is definitely going to require consultation. You can go to the link in the profile to schedule that. Can I petition to travel with the U visa? So it does not allow for travel, and you have to be very careful with that. I am DQ since November 2021. I haven't received my interview date as yet. Any advice? Unfortunately, you are in a basket full of the same people in the same situation. It's just based on the embassy and how long they're taking. Let's see. So if I have a green card, I'm married with a US citizen, can she deport me? No, she can't. If she's threatening to do that, especially if you have the 2-year green card, then that's a problem. And she is definitely not doing, she's mistreating you and she's abusing you with the immigration process. A US citizen can't deport you. No, it doesn't stop them from reporting you, and it's really up to the immigration to determine whether they want to investigate any claims made to them. There's nothing stopping her from doing that, but her formally saying, she wants you gone and getting you gone, it doesn't exactly work that way. But if your spouse is threatening to do that, get coverage, get legal advice. If you have the 10-year green card, it's unlikely unless she can prove and the USCIS decides that they want to pursue any kind of wrongdoings against you, like fraud or marriage fraud. But just saying that she's going to get you deported, she doesn't have the power to do that. And that's abusive. Just check the Visa Center I-130 petition, but can't remember what else to do. Okay, so Safrana, I really wouldn't be able to walk you through that because I'm not your attorney. Now, this is a good time for me to remind you all that I am just on here to give general information. I don't give specific legal advice. So this is where it's very important to make sure you get personalized legal advice, to understand your process, get coverage, make sure that you are protected. I'm 44 years old and I'm French. What will be the best visa to apply for? how to get the green card. So it depends, so many different ways. There are over 20 ways to get your green card. So it really depends on what your facts are. That's where the consultation is very important. My I-129F was transferred to Vermont Center. I heard Vermont is for troubled cases, so not necessarily. It doesn't mean that your case is troubled. Can I have a 2A numbers? Yes, that's a possibility. Thanks so much for the follows. I appreciate it. I really appreciate that. Now go ahead, share the live. I'm on here every day. I'm on here at around 4 p.m. Eastern time, Mondays through Fridays. Of course, there will be some days that I don't make it, but for the most part, I am here, and I'm here to give you great information, to educate you, just like I did, about your possibilities of doing adjustment of status, even if you've been ordered deported more than 10 years ago. And if you've had TPS, you previously entered the country without permission, but you've had TPS, you've traveled on advanced parole on TPS, you would then have legal entry to qualify for adjustment of status. So these are often situations that really cause complications and previously stop people from applying for adjustment of status. Well, now I'm here to say that now there are options because of this. So go ahead and schedule and this. So where are you located? So I'm located in Boca Raton, Florida. However, I travel all around the country to represent my clients before the USCIS. So I have my clients all over. No matter where you are, I'm able to represent you. So send off my I-130. I'm going to do fingerprints because I already did one previously. You may not. You may get a notice that says they're going to reuse your old fingerprints. You answered about my daughter in Jamaica, and I didn't hear. So Tashi, bless. I'm sorry, I didn't see your question, or I'm way down now. Will an undocumented immigrant with a foreign passport be able to travel by air after May 2023? So now, if you want to travel with an ID, you're going to have a special star on it, right? However, if you want to travel within the United States, you do have to have a valid passport to still be able to travel. Thank you. I understand. Just couldn't remember what said. Thank you again. Okay, so it's the National Visa Center. Filed since 2019 for removal of conditions, have not gotten the second card yet transferred to Vermont. Yeah. So it's taking a long time. If you're having any issues, that's where it's important to schedule a consultation. How long is adjustment of status based on your experience? So my cases are going anywhere from 5 months to a year for adjustment of status. And I would say more on the 5 to 8 month timeline, but that does not mean that will be the case for you. How long would it take for a minor filing to come through if the child is in the US? So it could take anywhere from 6 months to 9 months if they're doing adjustment of status. All right, I'm heading on over to Instagram. If you want to follow me on Instagram, I am there. I post most of my content there. I do lives here every day, Mondays through Fridays, but I do post content on Instagram. So you are free to join me on The Immigration Attorney on Instagram, where we can continue this conversation. If I didn't get to your question, hop on tomorrow where I can address your questions again tomorrow. Thanks for your time. Thanks for your patience as I got through your questions. I will be back tomorrow at around 4 p.m. to answer your questions. Have a great day, everyone. See you tomorrow. Bye-bye. And thanks so much for the love and the follows.